Hey, good morning. You want to do the arraignment first or which one? Okay, come up, man, please. So she has a co-defendant. Do you guys represent the co-defendant? Do you know?
No.
No?
I believe the defendant also has a felony because he had prior thefts on it,
Oh,
but she is a first-time offender. And her,
Um,
and her involvement in it is not as much
All
as
right,
the
let's
co-defendant's.
unpack
Ms.
this.
Ayala, you're
First-time
charged with,
offender
you speak
status
English,
can be a
ma'am?
big deal in
Okay,
court.
Ms. Ayala, you're
But
charged
notice the
with
judge
theft.
brings up the
Shh.
co-defendant's
You are
prior
facing up
thefts.
to a
That
year in
could
jail
complicate
and
her
or a
case.
$4,000 fine.
Quick question
We
for
are going to
you.
do
Should someone
probable
be
cause. You
judged
have
by
the right to
their
remain silent.
company,
Anything
even
you
if their
say
role
can
was
or will be used
minor?
against you.
Comment
You have
guilty
the right
by
to have an attorney
association
present. If you
or
cannot
judge me
afford one,
solo
one will be
below.
appointed to you, ma'am.
Much as the co-defendant's.
Ms. Ayala, you're charged with, you speak English, ma'am?
Yes, sir.
Okay, Ms. Ayala, you're charged with theft. Shh. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
On March 9th, 2025, at approximately 5:43 p.m., an officer was dispatched to a Best Buy in Houston, Harris County, Texas, in regards to a theft. The call notes advised that the suspects had left the location in a red Dodge Challenger with a temporary tag that started with 74. The officer located a vehicle consistent with the description about 0.8 miles from the business. The officer was also given a description of the suspects. A traffic stop was initiated. The officer immediately recognized Defendant Sauceda from previous thefts from Best Buy. Defendant Sauceda stated he took 2 items from the Best Buy without paying. The passenger, who is identified by her Texas driver's license as Defendant Ayala, and Defendant Sauceda entered the store and went to a cell phone station. Defendant Ayala distracted the cell phone employee while Defendant Sauceda used a pair of scissors to remove 2 cell phones and exit the store. Shortly after, Defendant Ayala received a text message from Defendant Sauceda, and she immediately left the store without purchasing any items. The total value was $1,499.99, and the 2 items were located inside the vehicle.
Whoa, that's nearly
Ms. Ayala, I'm going to find that there's
$1,500 worth of
sufficient
stolen
probable cause
goods,
to go
right on
forward
the
with the
edge of
case.
felony
I'm now
territory in
ordering you
Texas.
not to have
Did you
any
catch the play
contact with the
here?
co-defendant
One
in this
distracts,
case.
the other
If I find
snips.
that you do, I
Text
will revoke your
messages,
bond, put you
prior
in jail.
IDs,
No
items
more
recovered
PR
in the car.
I'm
That's a
also
textbook.
ordering you and barring you
Organized
from
retail
going to
theft
any
setup.
Best Buy in
Not exactly
anywhere.
Ocean's 11,
Do you
but
understand?
still, this could
If I
stick
find
hard
that you
in
pick up a
court.
new case,
Vehicle.
Ms. Ayala, I'm going to find that there's sufficient probable cause to go forward with the case. I'm now ordering you not to have any contact with the co-defendant in this case. If I find that you do, I will revoke your bond, put you in jail. No more PR bonds. I'm also ordering you and barring you from going to any Best Buy in anywhere. Do you understand? If I find that you pick up a new case, if I find that you violate these conditions, that's it. So do you mind filing those conditions, no contact with the co-defendant, no going to any Best Buy, anywhere? And then now you have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with them. If they tell me they can't get a hold of you, I will issue a warrant for your arrest. For now, I'll have you sign a reset with Victoria. We'll have you take your seat in the jury box. So we'll get your bond condition. We'll have you sign it. And after that, you'll be free to go. Okay? Thanks. Both of you are charged with criminal cases. You're charged with driving while intoxicated. Both of you have breaths over 0.15. That makes it now a Class A misdemeanor. You are facing a year in jail and or a $4,000 fine. Both of you have negotiated plea bargain agreements for essentially slaps on the wrist. After today, each of you will be facing 90 days in jail for any other DWIs that you pick up. And I will tell you now, if you're ever in a car, you get pulled over, first thing officers do is they look at your record. If they see that you have prior DWIs and they go up to your window and they smell alcohol or dope, it's probably not going to go well for either of you. So if I were you, I would never get into a car and drive, even if you've had a sip of alcohol, because you're taking a huge risk, especially if you're not in this country with permission. Do each of you understand?
Yes, sir.
A minimum of 90 days in jail from now on. No more slaps on the wrist. Both of you give up a lot of rights by entering into these agreements. You're pleading guilty to these charges. They will go on your record. They will be there forever. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers, If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. Both of you give up the right to appeal as well, meaning that once you plead guilty, there's no changing. Do each of you understand?
Sí, señor.
Yes, sir.
Is this what you want to do?
Yes, sir.
Sí, señor.
Yes, sir. Yes, sir.
How do you, each of you plead to the offense of driving while intoxicated?
Sí, culpable, señor.
Guilty, sir. Guilty,
I
sir.
want you to understand that everybody makes mistakes. When you continue to make mistakes, when you endanger other people's lives,
Now this is
that's when we
serious.
really
The
come
judge
down
just
hard
warned
on
them,
you.
no more slaps
There
on
is
the
a
wrist. One more
$4,500
DWI and
surcharge
it's
that would
jail,
normally
hefty
apply
fines,
with these
and
types
possibly
of cases.
deportation. This
I
isn't just
understand
about
that mistakes
punishment,
happen,
it's a message.
and I will take it
What do
off
you
of you
think?
now.
Should
But
repeat
if you
DUI
make another
offenders get harsher
mistake and you pick
penalties
up
or more
another
support to
DWI,
reform?
that's when we really come down hard on you. There is a $4,500 surcharge that would normally apply with these types of cases. I understand that mistakes happen, and I will take it off of you now. But if you make another mistake and you pick up another DWI, a second DWI, it's a surcharge of $6,000. And if you don't pay it, every $100 you owe, you sit 1 day in jail. Not to mention the minimum 90-day sentence that there is. So get a clue. If you want to drink 32 beers, 52 shots of tequila, take an Uber or find another way to get around. Do you understand?
Sí, entiendo.
I'm
Yes,
going to
sir.
suspend both of your ability to drive for 90 days. Do not drive. Otherwise, we will be back here. Mr. Chirinos, I'm going to sentence you to 6 days in jail. I will give you credit for the 2 days that you have done. Mr. Hernandez, I'm going to sentence you to 3 days in jail. I will give you credit for the 1 day that you have done. Good luck to you, gentlemen. Thank you, guys.
Vamos.
Joseph Martin?
Yes, sir.
So, Mr. Martin, you have a total of 4 open cases. You're charged with 4 counts of assault. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On March 8th, 2025, officers were dispatched to 4527 Perry Street in Houston, Texas, in Harris County regarding an assault. The complainant, Hayes, stated that she was in a verbal argument with the defendant and that led to her being pushed by the defendant. Complainant Hayes said that she hurt her hand due to being pushed into a car with the defendant and that she felt pain. The complainant, McDaniel, then stated that she confronted the defendant due to see her friend getting assaulted by the defendant. The defendant then started swinging and struck the back of McDaniel's head, and that complainant felt pain as well. Complainant Powell then stated that she was assaulted by the defendant due to also trying to defend her friend, complainant Hayes. Complainant Powell says that he approached them to confront the defendant, and the defendant just started swinging and that she got struck by the defendant. Complainant Powell stated that she was not recall how that she was hit, but that she felt pain. Complainant Martin stated that she knows the defendant from school and they both attend TSU. The complainant Martin stated that she was trying to calm the defendant down but does not remember the physical assault due to her being knocked out unconscious by the defendant. Complainant Martin felt pain. A witness stated that she saw the whole incident and saw that the defendant was arguing with complainant Hayes and that the defendant started pushing complainant Hayes into a vehicle. Complainant Martin was then trying to de-escalate the situation and stated that when she saw complainant Martin get struck by the defendant and get knocked unconscious for approximately 2 minutes.
Is that number 3 or 2?
That's 4.
That's the 4th.
That's 4th, Your Honor. The witness then stated that she saw the defendant punch complainant Martin on the left side of the face. The defendant admitted to being involved in the physical altercation with the complainant and pushing them away. The complainant 2 had a knot on the back of her head. Complainant 3 had a small swelling on the left side of her face. And complainant 4 had small swelling under her left eye and was transported to the hospital due to being unconscious.
All this happens at TSU?
It is. It was a party, yes, Your Honor.
Mr. Martin, I'm going to find that there's probable cause to go forward with your case. I'm now barring you from going to TSU.
Yes, sir.
I'm barring you now from going to TSU.
Oh,
I'm also ordering you as a condition of your bond not to have any contact with any of the complaining witnesses in this case, not to consume alcohol, illegal drugs, not to be in possession of weapons. If I find that you're a danger to my community, I will do everything in my power to take you off the street. Do you understand?
sir, I understand. May I ask what, this bar?
You have the ability to hire a lawyer, Mr. Martin.
Oh, sir.
You work. I'll have you fill out an application. Deputy Miranda will give you an application. I'll see whether you qualify for an appointed lawyer. I'm going to have you sign a receipt with Victoria, then I'll have you meet with Felicia for your bond conditions. Life is way too short to sit in a box that's 6 by 9, man. Keep my city safe, otherwise it's going to go sideways real quick. You understand?
Yes, sir, I understand.
Okay, come on.
Thank you. I'll go.
Mr. McQueen, you're charged with indecent assault. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On April 4th, 2025, in Harris County, Texas, a law enforcement officer was dispatched to a sexual assault call and made contact with the complaining witness, who stated that her and the defendant, her stepfather, were on their way home. The defendant began talking about the CW's boyfriend and then stated he wishes that she was his so he could, and this is quoting directly, Your Honor,
Say it.
taste her, fuck her, and that her innocence draws him towards her. Once inside the residence, the defendant came up from behind the complaining witness, wrapped his arms around her, and proceeded to kiss and lick the side of the complaining witness's neck. The complaining witness attempted to get away from the defendant, but the defendant restrained her until they fell to the floor, and the complaining witness was able to break free, run to her room, and lock the door. The complaining witness is 19 years old.
Mr. McQueen, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case. I'm now issuing what's called a magistrate's order of emergency protection. This is a court order that identifies her as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives, or where she works. Do you understand?
Yes, sir.
If you violate this court order, the state can and probably will file a violation of protective order, and that is the capital murder of misdemeanors. Don't pick up a violation of protective order.
Yes, sir.
You're ordered not to have any contact and not to be in possession of weapons. Okay, so now we need to talk about a bond. Guys, what say you?
Due to the nature of the case and the defendant's criminal history, this state will request a $5,000 bond. You said.
What, was that 5,000, Judge? 5,000 is fine, Judge.
Okay, I'm gonna set your bond per agreement of the parties at $5,000. Do you have a bonding company here now?
We do.
Okay, I'll allow you to walk out with your bonding company. Do not pick up any new cases. Do not. He has 2 prior AFMs, one of them against the same complaining witness. Can you please let me know?
Yes, Your Honor, if I can just have a moment.
Yeah.
What's that?
I don't know if, I see
It's
2
not the-
AFMs,
not the
I'm
same
just not.
I don't believe it is the same person, Your Honor, from what I have,
Small baby.
in this case.
Like 10 years.
It is not some complaining witness, Your Honor.
Okay, so we'll set your bond at like I said, at 5,000. Don't pick up any new cases. Don't do anything to violate the conditions of this bond, otherwise it's not gonna go well for you. Do you understand?
Yes, sir.
All I want is my community safe. I'm gonna do everything in my power to protect it. So we'll have you now, since reset or no?
Are they posting their own bond?
Yeah,
Then we don't.
yeah, we're not gonna do a reset at this time because what'll happen is he'll get a 7-day, we can't essentially. So once he goes posts bond, you will get a 7-day setting. Just reach out to Victoria, email, and then we can give you a further date so you just don't have to come back in a week.
Thank you, Judge.
We'll have him sign all his conditions. Now, do not leave until you sign your conditions, and after that, we'll let you go. And then we'll let him go with the bonding company.
Thank you.
Yeah, okay, thanks, guys. All right.
We worked out a 4-year deferred upstairs, and he's applying for interstate compact. They pushed us to Monday to get the supporting documentation. Judge, I talked to Mr. Jurisic by email yesterday, and he's made a time served offer on the DWI here. I wanted to see if that's something the court's willing to accept, but that time
It's a
served.
first, right?
It is a first.
I'm okay with that.
That offer is dependent on him entering the plea on the deferred. So if we'll push to Monday, he's got a plea on the deferred to get he hasn't pled on the deferred because we pushed to Monday till he can apply for interstate compact because he's a California resident.
Come up, Mr. Greathouse.
Okay, just check. Probably around the 180 mark, I think it was.
Of course. I don't have a problem with it. Yeah. You have to be very, very careful. You know, here in our court, we do the fugitive cases. So I handle all the cases here where someone gets arrested in Harris County for an open warrant they may have in any other state, Wyoming, Delaware, California, Oklahoma. If you have a warrant that originates in another state and you're arrested here in Harris County, I handle all those cases. One of the cases that is most difficult and frustrating to deal with are the interstate compact cases. Because, and she's shaking her head over there because it really is, she's our fugitive prosecutor, because if you do something to violate conditions where they have to issue an interstate compact warrant and you end up in jail, you will sit there for months on end waiting for anything to resolve, waiting for the interstate compact people to do whatever they need to do to resolve cases. So if you are getting on this deferred upstairs, which is a very serious deferred, right? And you violate conditions and they have to issue a warrant, you could be months upon months sitting in jail. So the only thing I'm trying to tell you is take it seriously. Don't take it as a joke. Everything is done on timing, so you got to do stuff on time. Don't take off. It's the worst thing that you could possibly do when you're on a deferred. Just do what you're supposed to do, and everything ends up well. When you don't, on these interstate compact cases, it's a complete nightmare. You want Monday?
Yeah, please.
Absolutely.
Thank you.
Okay, so we'll push you off Monday, and then we'll see you then. Okay.